Now, there's one notable group of cases where there has been a great deal of unanimity, and those are cases involving business. I was struck to learn a statistic recently, since we last talked, that out of the 30 business cases that the court heard last year, 70% of them were decided unanimously or nearly unanimously. And just yesterday, you handed down a decision, a business case that was unanimous as well. Why is the court united in business cases and so divided in culture cases?
This is a matter that is for you to decide, not for me to decide. I don't think of a case as a business case. And that isn't just for popular consumption. I think of it as a case. I have a case. There is a statute. The statute is likely composed of language that doesn't answer this question very definitely. There are two sides to it. Otherwise, why did it get to the court? Since you look at these results, what's the result in the AFL-CIO briefs?
What's their percentage of winning?
Yeah.
I guess this notion was just the briefs in which the Chamber of Commerce filed cases, they won almost.
No, I wasn't asking that question.
I don't think the AFL-CIO filed briefs in those.
See, you're led around by whatever happens to be in the headline that day. I mean, if you want to do a sort of a real study of this, it might be interesting. I don't think it would be too interesting because I've been there for quite a while now. And what I've learned most of all, I think, is that the inside story of the court is that there isn't that much of an inside story.
How much does temperament matter? Getting along with colleagues, being friendly. When you worked on airline deregulation, you once said you were impressed by the fact that both sides would come together on a common result because they trusted each other and there was a sense of comedy. Does that matter on the court and is it an important part of leadership?
Yeah, temperament matters, or being, but it's a professional group. I say, and it's pretty true. I've said this for a long time. I've been there, I guess, 13 and a half, almost 14 years, and been to a lot of conferences. And I've never heard a word shouted or voice raised in anger, and we've had some pretty controversial stuff. And I've not heard one member of the court in that room say anything nasty or biting or critical personally of another. We get on well, it's professional. And I try to tell the law students this. I want them to understand that. I want them to understand you're a law student. I see you're going to be a lawyer. And a lawyer, it's a wonderful profession because both it requires your head and your heart. Every human being has a heart. And the emotions of your heart are not necessarily better than any other person's. But not everyone has a legal brain, for better or for worse. So I say to them, you have a good legal brain too. And it's a wonderful profession because you can put those two things together. Now, when you're talking on behalf of a client and you start getting emotional, all I can tell you is my own experience is that those on the other side pay less attention, not more attention to what you say. Oh, he's just emotional about that. Oh, she's feeling rather emotional about that. And let that word get around and you're going to convince them less. So what good would it do for me in that room to get up and say, but I think this is so important. Somebody on the other side, oh yes, I think it's so important too. What are you talking about? And so it would get nowhere. And therefore there's self-interest as well as just politeness and professionalism. But it is a professional group of people. They stick to the argument, they stick to the merits, and they go around and try to work out these very, very difficult matters.
And yet your dissent in the Seattle schools case, which we talked about in July, many people think was your greatest. And you were, if not emotional, you were very exercised and passionate, and you explained why. Can you imagine, remind us what you were so upset about, how that violated your conception of the democratic constitution, and whether you intend to get similarly worked up in the future?
I do not have an intent to get worked up about anything in the future. And whether there was a certain emotional content in that, and I don't know whether that added to it or subtracted from it. I have no idea. I have to write what I think in these things, and that case was a case in which I felt fairly strongly It involved affirmative action. We had previously held, there are two ways, simplifying, but there are two ways of looking at the 14th Amendment. The 14th Amendment says that no state shall deny any person equal protection of the law, though that passed after the Civil War. That great phrase was the phrase that led the court in Brown to say, it says equal protection of the law, and we look around this country, and it isn't there. And all you had to do was open your eyes, and it wasn't there. And therefore, a kind of movement started in the courts, taking a very long time, not yet finished, to make certain that that promise became a reality. What promise? The promise that people would be treated equally, fairly. Race wouldn't matter. Race wouldn't matter. Now we come to efforts by government, University of Michigan, local school district, to make race matter to some degree, but to help those who were previously kept down, to help that minority become better integrated into society, American society. And then the great legal question is, those words, equal protection of the law, do they permit it? Now here there are two views. View number one, no, they do not permit it. The Constitution is colorblind. Race is race. Don't get into this business of trying to help some people because of race or to hurt others or whatever it is, because you can't easily distinguish among them, and it doesn't say anything about, it says, it's what old Justice Harlan, great man who dissented in Plessy v. Ferguson, said, colorblind, that's it. I won't go into all the arguments, but I promise you there are a lot of very, very, very good arguments for that position. Opposite position. They'd call it the teleological position. That's good, because hardly anyone knows what that means. But they call it the purposive position. The purposive position is that those words, equal protection of the law, were put there in order to help people who previously had been slaves or their families had been slaves become full members of American society. That's why they were put there after the Civil War. And that means that a law, even today, which tries to further that purpose, is not as likely to be unlawful. See how careful I put that with lawyers' triple negatives? I'm saying it's just not the same standard. It's a little bit more favorable. You're trying to do something that's a little bit better, and the law can make that distinction. Not everything's going to be lawful, but it's just you get a little bit of a leg up, legally speaking. And now which is it? Which is the right interpretation? That colorblind view or the teleological view? Now, in a case called Grutter, involving affirmative action used by the University of Michigan, which is a state institution to allow people into law school, we had to face that question. In 5-4, we said it's probably that teleological purposive view, because they can do it.
Some law professor, some smart aleck, came up with a statistic that I have to look at here because I don't have it from memory. He counted up your record last term, and he came to a very different conclusion. He said that there were 18 non-unanimous decisions last term. You voted to uphold the challenge law in only 4 of these cases, compared to Justice Kennedy, who was deferential in 9 cases, and Roberts, who was deferential in 14. So Justice Breyer, never mind about you, I've got a lot riding on you as the defender of judicial restraint. And I wonder if these numbers suggest that you're changing your turn.
Don't stop writing. That's a statistics. I mean, anything like the totally general kinds of very abstract views that you're talking about will maybe over a very long time reveal itself a little bit more or a little bit less. There's nobody, no sensible judge, no judge of which I am aware, thinks that every law of Congress should be upheld, because sometimes a law of Congress does, in fact, violate the Constitution. one of the jobs of a Supreme Court is to know when this just goes too far. What I think of the court generally is I think we have this document, and what Hamilton and Madison meant it to be is a document that sets a kinds of borders around a system which it creates, which system is a democratic system. Institutions are set up for people to make their own decisions, not to have judges or any other group of people tell them what those decisions ought to be. The purpose of the institution is so that there is a democratic way for people to decide among themselves what kinds of cities, states, towns, and nation they want. At the same time, I said it sets up a system, and the system has boundaries. The boundaries are there so that the institutions can work, so there's a degree of protection for basic human liberty, so that power is divided, state, federal, in 3 branches, so no one becomes too powerful, so that there's certain guarantees of equality, and so that there's a rule of law. Now those call them the boundary conditions. And really, when the court is at work in the constitutional area, what it's trying to do is to decide whether that process that we described went too far and violated a boundary condition. Now, there is no exact answer as to how you do that. All you can say is it's very often very tough. I like to think when I was 7 years old and used to go home and listen to the radio, and they had Tom Mix, and then they had Captain Midnight, and then they had Sky King of the Mounties. Now, I learned from Sky King of the Mounties that he's off there on the frontier up in Canada, and that life was tough on the frontier. So I said, well, that's where I am. I'm on the frontier. We're deciding whether it's on this side of the boundary or that side of the boundary. And it's hardly surprising, given the nature of that boundary and the cases that come up, that people sometimes think it's here and sometimes think it's there. And what I think the ordinary person reading the newspaper about it sometimes loses sight of is that no matter how things turn out at the boundary, probably more important decisions are being made within that democratic space. And that's the place, since it's so huge, that actually, not the courts, determines what the country's like. And now that's a general view. And so sometimes it'll turn out we have these boundary conditions. You're probably one of those cases you're thinking of was an abortion case. The campaign fine? Well, no, it wouldn't have been campaign. I don't know which they were. But regardless, long-run tendencies are long-run.